Good evening, everyone. We are here tonight for our Ministry of Municipal Affairs candidate and third-party advertiser session. This one's being hosted by Clearview Township, the town of Collingwood, and the town of Wasaga Beach. We're joined here by the Ministry of Municipal Affairs and Housing, specifically Dave Bardwaj and Bridget Foster. They're going to provide attendees with an overview of the Municipal Elections Act, campaign rules, election finances, third-party advertising rules, key dates, and they're going to outline various roles and responsibilities of elected officials and municipal staff. I'm Sasha Helmke-Plater. I'm clerk for the Township of Clearview, and with me I have our elections team. I have Jesse Molnar, Emma Coleman, and Shannon Pierre. And I'm going to take it over to Clerk Rubley from Wasaga Beach, and she can introduce her staff.
Thank you, Sasha. So my name is Nicole Rubley. I'm the General Manager of Legislative and Development Services and the Municipal Clerk for the town of Wasaga Beach. And with me, I have Carly Murdoch and Laura Borland, both Deputy Clerks with the municipality.
Good evening, I'm Sarah Almas, and I'm the Director of Legislative Services and Clerk for the town of Collingwood. And tonight I have with me Jordan DeJong, and he is our Information Management Specialist, and he's part of our election team.
Thank you very much. I'm going to turn the evening over to Bridget and Davon, and they're going to start their presentation.
All right, hi everyone. Thank you for coming. I'd like to thank Clearview, Collingwood, and Wasaga Beach for having us at this event, and for Clearview for letting us use this lovely council chamber. So just to kind of switch to our disclaimer slide, please. So these slides are meant to be a summary of some of the sections and should not be relied on for legal or official purposes. I do want to stress we're not lawyers. To my parents' disappointment, I did not do law school. So please seek legal advice when necessary. We will also not be able to cover every aspect of municipal elections, but hope that this will provide you with a better understanding of the process and the legislation and improve your comfort level overall. Lastly, I want to congratulate you all for taking an interest in your community and in local government as a whole. Whether you're interested in serving on a municipal council or a school board, or registering as a third-party advertiser. So if we can please go to our next slide. Perfect, thank you. All right, so the slide here outlines some of the topics that we want to cover during this session. So we'll talk about the roles of elected members of council, the head of council and municipal staff, as well as the role of a school board trustee. We'll also talk about the nomination process and how a candidate withdraws the nomination. Also, what happens if a candidate files for a nomination and then changes their mind about which office they would like to run for. We'll take you guys through some key dates, as well as who is able to run for municipal office and school boards and who are not. We'll also give you some general rules and election finance rules as well. Things like campaign spending limits, contribution limits, campaign expenses, borrowing, what expenses are exempt from the spending limit, financial surplus and deficit, financial reporting at the end of the campaign period as well. We'll talk you through compliance audits, which can be initiated by an application. We'll go through some penalties as well, general information about the voters list and rules on proxy voting, the rights of scrutineers at polling stations, recounts, and we'll end the presentation with some resources. You can find some detailed information, which will be on the second last slide. So we'll go to the slide for the roles and responsibility of elected officials, and then one more slide, please. Great, so you're considering running for a municipal office. Local government is the level of government that is closest to the people and is the most accessible and representative and responsive to the needs of the community. You've made the decision to throw your hat in the ring, or you're just thinking about the process and curious how to go about it. This might be something you've always wanted to pursue. You want to make a difference in your community. You might not be happy with some of the decisions that have been made, and you might just have a passion for politics. Regardless of your reasoning, it's a 4-year commitment. It'll be filled with challenges, excitements, and disappointments, hard work, but most importantly, a great deal of satisfaction. So Ontario's municipal government delivers local services, while the province establishes a legislation and policy framework. The Ontario government sets standards for many local services, such as land use planning, building regulation, and social housing, and the province provides funding to municipalities for delivery of some services. The ministry also works in partnership with the municipal sector to support efficient and responsive local government that are sustainable and investment ready. Local government is a challenging environment with high expectations and limited resources. Often you're doing more with less. There's often a limited understanding of the roles of council and staff. Government is not like other businesses. You can't make everyone happy, so council must make difficult decisions in the best interest of the municipality. Before we get into an overview of the Municipal Elections Act, we want to provide a brief summary of the role of elected municipal officials and the role of staff. Just to note that the information about the role of council and staff and accountability and transparency can also be found in the Councilor's Guide on the Ministry's website. We will be talking about the Councilor's Guide a lot. It is a very good and useful handbook for not only staff, but also people who are looking to run for a municipal election. Okay, next slide, please. Great, okay, so council and staff roles. So first let me start by saying that Section 2 of the Municipal Act stipulates that municipalities are created by the province to be responsible and accountable governments with respect to matters within the jurisdiction, and each municipality is given powers and duties under the Municipal Act, as well as other pieces of legislation, for the purpose of providing good government. The Municipal Act is a legislative framework for municipalities which seek to balance local autonomy and flexibility with accountability and transparency of municipal operations. The key to any organization, whether that be government or business or industry or even local service clubs, is for everyone to understand their respective roles and relationships. In the next few slides, we're going to review the role of the mayor, the mayor's role as the chief executive officer, the role of council, and the role of municipal staff, which are all key to an effective and efficient local government. Next slide, please. Okay, great. So, the role of council is outlined in Section 224 of the Municipal Act, and the goal is to represent the public, to consider the well-being and interests of the municipality, develop and evaluate policies and programs of the municipality, determine which services of the municipality provides, ensure that the administration and other policies, practices, and procedures are in place to implement decisions of council, and maintain things like financial integrity of that municipality, as well as carry out duties of council under the Municipal Act or any other act as well. Next slide, please. So now we'll kind of head on to the role of head of council here. So the role of head of council is to act as a leader. The head of council is the chair of the meeting of the council and is the public face of the municipality. Next slide, please. Thank you. Although the legislation refers to the head of council as the chief executive officer of the municipality, this may be confusing to people with a business background. The head of council actually has very few powers that can be exercised, independently of the rest of council, except where this is specifically delegated in cases of emergency or in context of procedural matters during a council meeting. The head of council has no greater power than any other individual member of council. It is important to note that generally council makes decisions, not any individual member of council, including the head of council. However, there are 216 municipalities that are subject to the strong mayor framework, whose heads of council have been given authority to make certain decisions. These will be covered in greater detail in the upcoming slides. It's also important to clarify that heads of council always have a vote. There's often confusion with some people who think the head of council can only vote in case of a tie. This is not true. The head of council does always have a vote. Another clarification regarding voting. During a recorded vote, an abstention from voting is recorded as a negative vote. The act is silent in regular voting, such as non-recorded votes. You should look to councilor's procedure bylaw to determine how abstentions are dealt with in a non-recorded vote situation. So now we'll move on to the next slide of strong mayor framework. Perfect, thank you. So in some municipalities, the head of council has additional powers and duties known as strong mayor powers and duties. These additional strong mayor powers and duties apply to the head of council in any designated municipality, regardless of whether they are called mayor or another term. These additional powers and duties for heads of council apply to designated municipalities. The list of those that have been delegated can be found in Ontario Regulation 53022. Some strong mayor powers are related to provincial priorities identified in regulation under the Municipal Act, as well as the City of Toronto Act, and these are as follows. So to build 1.5 million new residential units by December 31st, 2031, construct and maintain infrastructure to support housing, including transit, roads, utilities, and servicing. Next slide, please. Perfect, thank you. So to begin this slide, let's outline some of the strong mayor powers and duties. I'm going to put my glasses on for this one. All right, so the first thing we have is to direct municipal staff to do certain things related to their additional powers and duties. Choose to appoint the municipality's chief administrative officer, hire certain department heads, and establish and recognize departments, create committees of council, assign their functions, and appoint the chairs and vice chairs of committees of council, appoint the chairs and vice chairs of prescribed local boards, bring forward matters for council consideration if the head of council is of the opinion that the considering matter could potentially advance provincial priorities, propose certain municipal bylaws if the head of council is of the opinion that the proposed bylaws can again advance those provincial priorities. Council can pass these bylaws if more than 1/3 of council members vote in favor. They can also, the mayor with strong mayor powers can also veto certain bylaws if they feel that all or part of a bylaw could potentially interfere with provincial priorities. And then also propose the municipal budget, which would be the subject to council amendments and separate mayoral veto and council override processes. So some of the powers can be delegated by the head of council. These are marked with the single asterisk. Some powers relate specifically to prescribed provincial priorities, which we talked about before. These are marked with the double asterisk. It is worth mentioning that the head of council in a strong mayor municipality is subject to existing accountability and transparency rules, as well as certain additional rules. Generally, when the head of council uses their strong mayor powers or duties, they're required to provide written documentation to the municipal clerk and members of council by the next business day. They must also make a written documentation available to the public as well. Written documentation requirements vary with respect to some of the powers and duties, such as the use of the veto, aspects of the budget process, and the power to direct staff. Implementation of strong mayor framework is a local matter. It is up to the head of council, and the municipality to implement the framework in accordance with the legislation and the associated regulations. I just want to note that the decisions about when and where to seek legal opinion is unique for each head of council and local circumstances or situations. In practice, this means that each strong mayor municipality may adopt local processes and procedures that best respond to the municipality's local needs and circumstances. For example, the head of council and the municipality may work together to establish a local process for council to provide input, to seek public input in relation to a strong mayor budget. So next we'll move on to the role of council representative roles. Perfect, thank you. So the next few slides will provide a bit more information on each of the roles of council as described in the Councilor's Guide. So for the representative role, in your role as a representative, you are elected by your constituents to represent their views when dealing with issues that come before council. However, your constituents may have many views and opinions, and you cannot represent them all of the time. For many issues, you will have to consider a variety of opposing interests and make decisions that will not be popular with everyone. You can't please everyone. You should use your judgment and decide based on the best interests of the municipality as a whole. A councillor should make a decision that supports the collective well-being of a municipality, balancing diverse needs and long-term interests. In practice, there's no single correct approach to the representative role, and on many issues, you may find that you fall somewhere in between two opposing viewpoints. nothing is black and white, right? Everything has different levels to it. Be sure to familiarize yourself with any policies or protocols that your municipality may have in place regarding the handling of complaint and citizen inquiries. Although you may want to find some way of helping, which is very admirable, remember to consult municipal staff. If your municipality does not already have a complaint policy, council may want to consider adopting one. Additionally, there may be circumstances where decisions are made by designated staff that operate at an arm's length from the municipality, and where it could be inappropriate for an elected official to interfere or be seen interfering. Examples of this would include decisions made by the fire chief, the chief building official, and the medical officer of health. A councillor who has made promises that cannot be kept may lose credibility with the citizens and strain their working relationship with staff. As I kind of mentioned before, each individual council member has one vote when making decisions. Every member of council should vote on matters in the best interests of the municipality as a whole. And every member should respect each other's viewpoints during and after debating an issue at the council table. Once a decision is made by council, it is a decision of the municipality, and staff are required to carry out and implement that decision. So next we'll talk about the role of council in the policymaking role. So some council decisions are routine. Others establish general principles to help guide further actions. Those are often considered policy decisions. Some policies can be specific, like a bylaw requiring dogs to be kept on a leash in a public area. Others can be more broad and general, such as the approval of an official plan. So how is policy made? So as you can see on our slide, we have some very beautiful fun boxes. And basically, this slide would outline the general process undertaken during the policymaking role. So again, the Councilor's Guide, which again is a great resource, does provide a lot of detail on the policymaking process. I highly recommend that you all take a look at that. But for now, I'll provide you with kind of a high-level overview. So first, you start by identifying the issue. As council, you agree on what the issue is and what the objectives are. Council will then direct staff to research the issue further and identify and recommend options to council. There may be the need to consult with the public and consider their feedback. Council will then review staff information and consider factors such as demand on time to implement the policy and any other cost implications as well. Council then makes their decisions on the best course of action and adopts the policy from there. Later, staff is directed to implement that policy. After policy is implemented, council would work with staff to evaluate the policy and make any amendments that may be required. In practice, policymaking is sometimes less orderly than what happens on the slide. Slides are a couple boxes, things are a lot more complicated because of a couple factors. So oftentimes there's a rapidly changing environment. The issue facing you could be complex, or it could be more difficult to single out problems that require more immediate attention. There could be differing and sometimes strongly held views by stakeholders and members of the public. There could be a lack of time to identify all possible alternatives and to conduct a detailed research and analysis. There also could be legal and financial implications, limiting what council may do. And the implementation of the policy, along with the establishment of monitoring and evaluation mechanisms, may be complex. So to recap, council is the primary policymaking body of the municipality, while the administrative staff is responsible for carrying out council's policy decisions. The two roles are distinct, but they can overlap. Although staff is responsible for implementing a policy, council may wish to develop appropriate reporting mechanisms to help ensure that policies are being carried out as intended and as effectively as possible, and so that council can follow the implementation progress. So next we'll go to the next slide. Council as a stewardship role. So council's objectives are to ensure that the municipality's financial and administrative resources are being used as efficiently and effectively as possible. There is a fine line between council's overall stewardship of the municipality and the administration's management of day-to-day activities. So generally, council monitors the implementations and its approved policies and programs, but the practical aspects of its implementation and administration are staff's responsibility. Essentially, the day-to-day operations of the municipality are left up to the staff. To be effective in this stewardship role, council may wish to have processes in place to ensure that policies adopted by council are being implemented, staff are administering services and programs as council intended, rules and regulations are being applied correctly and consistently, funds are being spent only as authorized, and the municipality's resources, financial or otherwise, are being used appropriately and as efficiently as possible. Establishing and following such policies and guidelines helps council leave the day-to-day details for staff to manage. Council is then freer to deal with exceptional situations, ensuring that policies are current and listen to issues raised by the public to represent the broader community interest at large. Before council can monitor and measure the municipality's administrative effectiveness and efficiency, it may wish to become familiar with policies currently in place. With input from municipal staff, council can determine whether policies are functioning well or if changes are necessary. So next we'll change slides and talk about the role of the Chief Administrative Officer. So for this, I'm just going to short form this to the role of the CAO. So the role of the CAO is outlined in section 229 of the Municipal Act, and that states a municipality may appoint a Chief Administrative Officer who shall be responsible for the following. So exercising general control and management of the affairs of the municipality for the purpose of ensuring the efficient and effective operation of that municipality, and performing such other duties as assigned by that municipality. So the function of the CAO within municipality is generally akin to the role of a chief operational officer in a business environment. The CAO is responsible for the general control and management of the day-to-day operations of the municipality. This may include developing and implementing appropriate internal administrative practices and procedures to ensure the efficient and effective and accountable operations of the municipality. To help understand the role of the CEO in a municipality, picture an hourglass. So council is on one end and you have staff and department heads on the other. The CEO is the middle part, the smallest part where the sand would kind of go through the hourglass. So for example, if council wants to give direction on a specific department, the communication would then go through the CEO. Likewise, if the department wants to give information or reports to council, it would also go through the CAO. So now we'll talk about the role of officers and staff. Perfect, thank you. So this is outlined in section 227 of the Municipal Act. So this would include implementing council decisions and establishes administrative practices and procedures to council decisions, undertake research and provide advice to council on policies and programs of the municipality, carry out duties required by legislation or other duties assigned by that municipality. A key feature of effective and efficient council is well-developed understanding of council-staff relations and the role of each party. The Counselor's Guide provides a list of ways that council members can assist staff to meet council's expectations. So some of these include having a policy requiring comprehensive job descriptions for all staff, providing clear policy decisions, directions, and expectations, adopt policies that complement and reinforce staff efforts, consult with staff before deciding on policies, and being prepared for council meetings. In turn, staff should provide well-organized agendas with supporting materials, provide sufficient timely information and analysis to council for council to make decisions easier, notify council of changes to any legislations and programs, provide advice on policy, including recommendations and options, identifying the costs and benefits for the community, both in financial and human terms, notify council immediately of any unintended or unexpected impacts of policy decisions, implement council decisions as effectively and professionally as possible. So as you can see on the slide, there are some staff positions that have statutory obligations. These include the clerk, the treasurer, the chief building official, and the fire chief. It is important that council not interfere with the statutory obligations of those roles. So for example, the clerk and the treasurer's positions have statutory duties or responsibilities assigned to them under the Municipal Act or other pieces of legislation. The building code would define the statutory duties of the chief building official, and the Fire Prevention and Protection Act would define the statutory duties of the fire chief. All right, so moving on to the next slide on council-staff relationships. So the Councilor's Guide, again, provides some very useful information on how council can work together. This slide provides you with a high-level overview. Again, another plug for the Councilor's Guide. It is incredibly helpful. Please look at that in detail. So council and their administration have different roles within the municipality, but the roles have common goals and purposes. In general, it is the role of the elected council to represent the community and set the direction and policy for the municipality, and it is the role of staff to manage people and resources to achieve council's vision. Council generally sets the policy direction for the municipality, and staff provides research and expert advice to help council in its decision-making process. Once council makes a decision, staff generally has a responsibility to implement the policy of council, for example, through administering, delivering services and programs to the community. Staff and council rely on one another to move the municipality forward. Both staff and council provide leadership. Council provides political leadership, while the administration provides leadership to the organization. The relationship between staff and council is interconnected, and it is important for council members and staff to respect one another's role so they can serve the public in the most efficient and effective manner as possible. Municipalities are required to adopt a policy on the relationship between members of council and members of staff. Municipalities have the flexibility to determine the content of these policies. So just some sample considerations regarding council-staff relationships and roles. So municipalities may wish to consider the following as they develop council-staff relationship policies: the appropriate role of council, the head of council, and other senior municipal officials. Some roles are set out in legislation, while others may be specific to the municipality depending on the local needs. Job description for all staff, which outline individual duties and responsibilities. Appropriate processes for directing inquiries, complaint mechanisms, guidelines for respectful working relationships, ethical standards, establishing an ethics executive to promote an ethical and impartial public service, the reporting relationship between staff members and members of council. Municipalities may also wish to consider how their policy on the relationship can complement their local accountability framework for council members. So moving on to our accountability section. So accountability and transparency is outlined in Part 6 of the Municipal Act. Ontario municipalities and members of council operate under a legislated accountability and transparency framework that include rules for the municipalities and rules for members of council and local boards. Ensuring accountability and transparency is one of council's roles under Section 224 of the Municipal Act and is a priority in maintaining public trust. Councilors are, of course, accountable to the public as elected officials. However, it is also important that procedures and policies are clearly set out and accessible, and that the day-to-day operations of a municipality are transparent. So the slide here outlines policies that council are required to adopt. So now we'll switch over to the next slide and we'll talk about some code of conduct. So codes of conduct usually set out expectations and standards for council conduct. Codes may help prevent ethical conflicts and help in the resolution. They can serve as a basis for council orientation and training and serve as a reference throughout the operation of the council's term. With the growing importance of accountability and integrity, more municipalities have adopted codes of conduct for members of council and certain local boards. Some have adopted other procedures, rules, and policies governing the ethical behavior of those members. Municipalities are required to establish codes of conduct for members of council and certain local boards, which must include certain subject matters. So these would include things like gifts, benefits, and hospitality, respectful conduct, including towards officers and employees of the municipality or local board, confidential information, and the use of municipal or local board property and equipment. So next we'll talk about the Integrity Commissioner on the next slide. Perfect. So section 22.3.1, 22.3.4, and 23.92 of the Municipal Act do talk about this. So since 2019, municipalities have been required to ensure that the public have access to an Integrity Commissioner. The Integrity Commissioner's role is to perform, in an independent manner, the functions assigned by council with respect to the following. So applying the local codes of conduct for members of council and certain local boards, applying local procedures, rules, and policies governing the ethical behavior of members, applying certain municipal conflict of interest acts, rules to members, requests for advice from members of council and certain local boards representing their obligations under the local code of conduct applicable to the member, local procedures, rules, or policies governing the ethical behavior of members, and certain sections of the Municipal Conflict of Interest Act. Also providing educational information to the public, the municipality and members of council and certain local boards about local codes of conduct for members about the Municipal Conflict of Interest Act. The commissioner's function also includes conducting inquiries into requests from council or a local board, a member of council or a board, or member of the public. This can include about whether a member of council or local board have contravened the applicable code of conduct. There is flexibility in how a municipality provides the responsibility of an Integrity Commissioner. And a municipality could consider the following possibilities. So appointing its own Integrity Commissioner and assigning all mandatory responsibilities to that commissioner, appointing its own Integrity Commissioner and assigning some of the mandatory responsibilities to that commissioner, and making arrangements for the remaining responsibilities to be provided by a commissioner of another municipality. Sharing an Integrity Commissioner with another municipality, this can, for example, happen across an upper tier. Making arrangements for all mandatory Integrity Commissioner responsibilities to be provided by a commissioner of another municipality. Additionally, a municipality could also consider assigning additional responsibilities beyond the mandatory ones to an Integrity Commissioner. When deciding on the arrangement of an Integrity Commissioner, a municipality may wish to conduct a number of things, including the following. So the anticipated workload of the Integrity Commissioner in that municipality, as well as the workload in another municipality if the commissioner is shared between them. A suitable budget for the anticipated workload of the Integrity Commissioner, such as payment, how the Integrity Commissioner will remain independent from the municipality, where and how the public, council, and staff will communicate with the Integrity Commissioner, especially if the municipality is making arrangements with an Integrity Commissioner of a different municipality. How long the Integrity Commissioner is expected to work for that municipality is also key. What will happen if any issues arise from this current work arrangement. The qualifications and skills of an Integrity Commissioner should also be taken into account. If the Integrity Commissioner reports that in their opinion a member has contravened a code of conduct, the municipality may impose a penalty in the form of a reprimand or suspension of pay for a period of up to 90 days. It is up to the municipality to decide how to proceed after the Integrity Commissioner's report has been submitted. So moving on to the next slide about accountability officers. Lovely. So to help support integrity and accountability in public office, municipalities may pass bylaws and appoint certain accountability officers. So these can include a municipal ombudsman, an auditor general, a lobbyist registrar, as well as a closed meeting investigator. So let's start with the municipal ombudsman. So they investigate in an independent manner decisions and recommendations made and actions done or admitted in the course of the administration of that municipality, local board, or certain municipal operations. The municipal ombudsman is separate from the Ontario Ombudsman, who also has a role with respect to municipalities, which we'll get into later. Next, about the Auditor General. So they will assist council in holding itself and the municipal administrators accountable for the quality of stewardship over public funds and achieving value for money in municipal operations. The Auditor General must also perform their duties in an independent manner. The Auditor General's responsibilities does not include the responsibilities of a municipal auditor. Moving to the lobbyist registrar, so they perform their duties in an independent manner, which are assigned by the municipality with respect to the lobbyist registry. This can include establishing a code of conduct for lobbyists and prohibiting former public office holders from lobbying for a specific time period. Then moving on to a closed meeting investigator. So they investigate, no surprise, in an independent manner, complaints about closed meetings. Should a municipality not appoint an investigator, the Ontario Ombudsman is the closed meeting investigator by default for that municipality. So moving on to the next slide. So let's talk about the Ontario Ombudsman. So the Ontario Ombudsman has a role with respect to municipalities. The role builds on the Local Accountability and Transparency Framework in the Municipal Act. This role is in addition to the Ontario Ombudsman's role as a default meeting investigator for municipalities that have not appointed a local meeting investigator. The Ontario Ombudsman supports transparency in government and may recommend improvements. The Ombudsman may investigate municipalities when a complaint is received or with the Ombudsman's own initiative. Although the Ontario Ombudsman may investigate, they cannot compel municipalities to take action. The Ombudsman may make recommendations to Council and the municipality as a part of their report, but it's ultimately up to the municipality whether and how they want to accommodate any recommendations made by the Ombudsman. It's also up to the Ombudsman on how to respond to complaints. For example, the Ombudsman's practice is to investigate complaints made to local integrity officers, like a local Ombudsman, only after the local complaint process are completed. The Ontario Ombudsman does not replace locally established complaint mechanisms or act as an integrity commissioner. Local integrity officers and municipal codes of conduct are an important part of Ontario's accountability framework. I do want to note, though, that certain local boards, for example, police services boards or children's aid societies, can be exempt from the Ontario Ombudsman's oversight. For more information on that, you can look at Ontario Regulation 114.15 under the Ombudsman Act, as well as the legislation more generally. For more information on the Ontario Ombudsman, including the process, please look at the Ombudsman Act, or you can find more information at the Ontario Ombudsman's website. So moving on to the next slide about privacy and confidentiality. So personal privacy and confidentiality issues are an important practical and legal consideration for municipal council and staff. The Municipal Freedom of Information and Protection of Privacy Act is the primary statute for privacy and confidentiality. It sets out rules for collection, use, and disclosure of personal information. According to these rules, council and staff, in most circumstances, protect personal privacy and only collect, use, and disclose personal information in accordance with these rules. So, for example, depending on circumstances, council and staff may or may not be authorized to obtain personal information in the course of their duties. This means that at times, council could not obtain this kind of information from staff. Municipal Freedom of Information legislation also regulates confidential information of other kinds, in addition to personal information. Other laws, including local bylaws, also regulate personal and other kinds of confidential information. Councillors who may have received personal or other confidential information in the course of their duties will have related responsibilities, such as protecting and safeguarding the information. Councillors may wish to check with the municipal staff about appropriate measures and the municipality's practices in general. For example, providing physical security of records to help prevent unauthorized disclosure or loss of confidential information. So next we'll move on to the next slide about the role of school trustees. All right. So the Education Act creates 4 different kinds of school boards. So we have English language public district school boards, which govern elementary and secondary English language schools that are not Roman Catholic separate schools. We then have English language separate district school boards, which govern elementary and secondary school in Roman Catholic separate school boards. Then we have the French language public district school board, which governs, again, elementary and secondary French language schools in non or other Roman Catholic separate schools. And then the French language separate school board, which governs elementary and secondary French language schools in Roman Catholic separate schools. School trustees are members of the school board. They are locally elected representatives of the public, and they are community advocates for public education. Only the board, not an individual trustee, has the authority to make decisions or take action. A trustee is often the first point of contact for parents and committee members who have questions or concerns about their local school. Candidates should contact the applicable school board for further information about duties and commitments of the role. So moving on to the next slide. So the role of the school trustee is to establish policy direction, participate in making decisions that benefit the entire school board while representing the interests of the constituents. School board trustees are accountable to constituents, the Ministry of Education, as well as families. So moving on to eligibility rules. Next slide, please. Thank you. Next slide again. Thank you very much. So you must be an eligible elector, which means you must be able to vote. So the list above kind of shows voter eligibility as well as eligibility to run for to hold office. You can only be nominated if, as of the day you are nominated, you are qualified to hold office under the Act and are not ineligible under the Municipal Elections Act or any other act, which is prohibited by law to be nominated or to hold office. So Section 30A of the MEA states that a person basically who is a volunteer firefighter, as defined in the Fire Prevention and Protection Act, is not considered an employee of the municipality. If a municipal employee wishes to run for office of the municipality's on that municipality's council, they must take a leave of absence before filing their nomination form. If elected, they shall be deemed to have resigned from the employment immediately before making the declaration for office. An employee of a municipality who wants to run for office in a different municipality does not have to take a leave of absence or resign, but they should check with their employer to see if there are any policies or practices that could affect them. So moving on to the next slide, great. So I just want to say that any questions about school board eligibility should be directed to the school board secretary. This is quite important. If you are an employee of any school board and you wish to run for trustee position of any school board in the province, you must take an unpaid leave of absence before you file your nomination form. If you are elected, you must resign from your job. You basically cannot work for a school board and be a school trustee in Ontario at the same time. So the following people are disqualified from being elected as a school trustee. So you cannot be a clerk, a deputy clerk, a treasurer, or a deputy treasurer of a municipality within the jurisdiction of that board. Any person not eligible to vote in that municipality. An employee of a school board unless they take unpaid leave of absence and resign if elected. Additionally, a judge of any court, a member of the legislature of Ontario, or a senator or a member of the House of Commons, as well as an inmate in a correctional institution. So moving on to the next slide about the nomination process. So the first day for filing nomination was May 1st. So nomination day, the last day in time for filing a nomination for the 2026 election, it's Friday, August 21st at 2 p.m. Please be there before 2 p.m. You have a lot of hardworking municipal staff, and after 2 p.m., they have other things that they need to do, as well as 2 p.m. is the final deadline. To withdraw a nomination, local election policies may state that a candidate must personally attend the clerk's office to withdraw a candidacy. If a candidate withdraws a nomination, they're still required to file a campaign financial statement covering all the financial transactions made in the campaign. If they have not spent any money nor raised any funds, they can click the box and sign the form, and it's deemed complete. If a nomination is withdrawn, the candidate is entitled to a refund of their nomination filing fee, but only after they file their financial/auditor statement by the required deadline. And just as a clarification, the nomination filing fee is only refunded once the candidate submits a completed financial disclosure of all financial transactions made up to the date the nomination was withdrawn. So the candidate's guide, the ministry has provided a few examples showing what happens when things change. So just also look at the candidate's guide again, just for helpful information on that. Next slide, please. Great. Okay, so starting May 1st until the close of business on August 21st, nominations can be submitted to the clerk from anyone who meets the eligibility criteria to run for office. Candidates must complete Form 1, which is a nomination form, and submit it to the clerk along with the applicable nomination fees. I don't want to keep you waiting on that. So the filing fee for anyone running for head of council is $200, and for all other offices, it is $100. The clerk must be satisfied that you are eligible to run in order to certify your nomination. The clerk can ask you to show identification or fill out additional form to prove that you are eligible to run for that particular office. The nomination must have original signatures. If your nomination is not certified by the clerk, you will not appear on the ballot. So if you are a part of a ward system, as long as you are eligible to vote in that municipality, you can run in any ward. If you do run in a ward where you do not live, you will not be able to vote for yourself, as you can only vote in the ward in which you live in. In addition to the legislative requirements, each municipal clerk may establish their own processes and procedures related to submitting a nomination. So it's important to contact your clerk so you understand the process in that municipality. Okay, so next slide, please. Perfect. Okay, running for a different office. So occasionally a candidate changes their mind and wants to run for a different office. You can run only for one office at one time. If a candidate files a second nomination, the first nomination is deemed to be withdrawn. If a candidate decides to run for another office, they have already collected the 25 endorsement signatures. They can use these endorsements to run for the other office. If a candidate decides to run for a different office on the same council or school board, and both positions are elected at large, everything from the first campaign is transferred to the second campaign, and only one financial statement needs to be filed. This is unless the candidate decides to run for a different office on the same council or school board, or both offices are elected by ward. Then the two campaigns must be kept separate, and two financial statements must be filed. So next we'll move on to third-party advertising on the next slide. Perfect, thank you. So a third-party advertiser is basically an individual, corporation or trade union that is registered in a municipality to promote, support, or oppose a candidate, or a yes or no answer to a question on a ballot. So third-party advertiser means an advertisement in any broadcasting form, including print or electronic or other media or other uses that have the purpose of, again, supporting or opposing a candidate or a yes or no question. So the next slide, please. Okay, so kind of turning to eligibility here. So only the following persons or entities are eligible to file a notice of registration to be a third-party advertiser. So that would include an individual who is normally a resident in Ontario, a corporation that carries on business in Ontario, a trade union that holds bargaining rights for employees in Ontario. The following persons and entities are ineligible to file a nomination for registration to be a third-party advertiser. So that would include a candidate whose nomination has been filed under Section 33 of the MEA, a federal party registered under the Canada Elections Act, a provincial political party, a constituency association, a registered candidate or leadership contestant registered under the Election Finances Act, the Crown and Red of Canada or Ontario, a municipality of a local board, and any group or association that is not a corporation. Okay, let's go to the next slide. Perfect, thank you. So the nomination process, the 25 signature requirement. So municipal council candidates are required to obtain 25 nomination signatures on Form 2. So just want to note though that the requirement for nominations to sign nomination forms does not apply to a school board candidate. Nominators can nominate more than one candidate and are not required to vote for that candidate. Nominators must meet eligibility requirements of the municipal elector at the time that they sign the nomination form. In a ward system, the nominator can be anyone who is eligible to vote in the municipality, not just that ward. Both the clerk and the candidate are entitled to rely upon the information provided by the nominator. If the nominator did not meet the eligibility requirements when they signed the document, and then they could be held accountable under the penalties of the MEA. Just a tip, if a candidate wants, they can provide more than 25 signatures, that might be a good idea, as if you find out that one of your 25 signatures are ineligible, you don't have to go out and find another signature. You have backup signatures just in case something of that happens. So now we'll just move on to the next slide, please. Perfect. So regarding registration of third-party advertisers. So individuals, corporations, and trade unions may register to be third-party advertisers. There's no registration fee to be a third-party advertiser. A third-party advertiser would register with the clerk at the local municipality as per section 88.61. An individual, corporation, or trade union, in person or by agent, file with the clerk of the municipality responsible for conducting an election a notice of registration to be registered for a third party for the election, and the notice must be filed in the prescribed form and must include a declaration of qualifications signed by the individual or by a representative of the corporation, trade union, or as the case may be. A notice of registration may only be filed with the clerk of a local municipality. Once registered, they may advertise in support of or opposition to any candidate being elected by the voters in that municipality. This would include council, trustee, and directly elected upper tier candidates. Any person or entity may advertise regarding any issue relating to the elections in that municipality without registering. To advertise regarding a question on a ballot, that will require registration as a third-party advertiser. For regular elections, the registration cannot be filled earlier than the first day of the filing of the nomination. It cannot be filed later than the Friday before voting day during the clerk's office hours. I just want to note that section 88.63 notes that once the clerk certifies the notice of registration, the individual, the corporation, or the trade union is a registered third party for that election. Third-party advertising is geographically based and is structured around the concept of influencing a specific set of voters in a specific location. So Clearview, for example, registering in that municipality where the TPA hopes to influence voters allows flexibility to support or advocate against any candidate in that specific geography. If an individual wants to influence voters in more than one municipality, for example, over 3 municipalities covered in a specific school board trustee election, they would have to register in each of the 3 municipalities and conduct their activities as 3 separate campaigns. Under section 88.7, if a municipality is satisfied that there has been a contravention of the act, things like advertising in the restricted period, as well as requirements therein other sections like 88.3 and 88.4, then it can ask the third-party advertiser to remove advertisements and discontinue advertising. Next slide, please. Perfect. Okay. So the third-party advertiser's registration is deemed to be withdrawn if they file a nomination. This means that the advertising campaign would automatically end and they file their nomination. If a corporation or trade union is registered as a third-party advertiser, it would not be affected by a person filing a nomination, as the person would not be the same as that entity. The third-party advertiser and the candidate would need to be careful to distance their activities, as third-party advertisers may not take place under the direction of a candidate. The existing campaign finances rules would not change. Finances related to third-party advertising campaigns cannot be transferred to a candidate's campaign. Again, the existing campaign finances rules would not change. A third-party advertiser who withdraws and closes their campaign cannot transfer that campaign to someone else. To maintain fiscal transparency around third-party advertising campaigns, the financial statement of advertisers who end their campaign early should reflect their finances as of the day their campaign ended. To register, the registration period for third-party advertiser runs Friday before voting day, which would be October 23rd, or the last day of the clerk's office hours is open before voting day in case of a by-election. So now I'll transfer everything over to my colleague Bridget, and you can hear her take us home.
Okay, so I'm going to cover the campaign finances sections. Next slide, please. Okay, so these contributions are outlined in the Municipal Elections Act under Section 88.15. Campaign accounts are only required if the candidate or third-party advertiser raises or spends money. So for campaigns where no funds are raised or spent, there is no need for a campaign account. Third-party advertisers will generally need to follow the same rules for raising campaign funds and financial reporting as candidates for office. Municipalities must establish rules and procedures regarding the use of municipal or local board resources during the campaign period. This must be passed by May 1st in the year of the election. This will encourage accountability and transparency, so ensure that you are aware of your municipality's policy in this regard. The practice of municipalities of providing candidate contact information on their websites is not considered a contribution. Next slide, please. So contributions from the candidate and their spouse are considered to have come from the same person and count against the self-contribution limit, which we'll discuss further into the slides. The rules for determining whether corporations are considered to be one contributor are clarified as if one corporation controls the others directly or indirectly, then they are considered to be the same contributor. If the corporations are owned or controlled by the same person or groups of persons, either directly or indirectly, they are also considered to be the same contributor. Next slide, please. So candidates and third-party advertisers cannot accept contributions from a federal political party, constituency association, or registered candidate in a federal election, a provincial political party, constituency association, or registered candidate or leadership contestant, a federal or provincial government, a municipality, a school board, or a business or group that is not a corporation. So in regards to volunteers, the value of services provided by volunteers is generally not considered to be a contribution. But if a professional, example for an accountant or a lawyer, volunteers to provide services for which they would normally be paid, the market value of the service must be recorded as a contribution by the volunteer and is also a campaign expense. So for example, if your accountant friend typically is paid $100 per hour and works 5 hours for you, you would document $500 as a contribution and $500 as a campaign expense. Trade unions and corporations are not eligible to contribute to candidates' campaigns, although they can participate in the election as third-party advertisers or make contributions to third-party advertising campaigns. Next slide, please. So campaign contributions are monies, goods, or services given to a candidate for his or her election campaign. Cash contributions may only be accepted up to $25. Any contribution that is above the $25 must be made by check, money order, or a method clearly showing where the funds came from. Every contribution that is made must have a receipt issued for it, though. Fundraising functions are events or activities held by or on behalf of a candidate for the primary purpose of raising money for the candidate's campaign. The price of admission to a fundraising function is a campaign contribution, and a receipt must be issued for the full amount. Receipts must be issued for every contribution and should contain the name and address of the contributor and the amount and the date. Next slide, please. The limit on contributions to any one candidate or registered third-party advertiser is $1,200, with the aggregate limit being $5,000. Since candidates and third-party advertisers are required to inform contributors of those contribution limits, you may want to include those limits on the receipts provided to the contributors. Next slide, please. Self-funding limits for municipal council candidates is based on the number of electors voting for the office to a maximum of $25,000 per candidate. This amount includes any contributions of goods, such as inventory from a previous campaign. So the formula for calculating the limit is $7,500 plus 20 cents per elector for the head of council, and $5,000 plus 20 cents per elector for other council offices. The highest self-funding limit that anyone can possibly have is $25,000. If the formula works out to above the maximum of $25,000, then you would still get the $25,000 limit. However, if the formula works out to less than the $25,000, then you get whatever the formula works out to. Next slide, please. So a candidate can open their campaign account with their own funds, but the candidate cannot loan funds to his or her campaign to kickstart it with the intention of getting it all back. The only way that a candidate can reclaim the startup amount is if there are leftover funds after the campaign period is over and prior to filing the financial statement. At this time, a candidate has the opportunity to reclaim funds from a surplus. The loan is not considered to be a campaign income, and paying it back is not a campaign expense, but if you or your spouse guarantee the loan and the campaign does not repay all of it back, the remaining balance is considered to be a contribution. So in this case, you need to keep in mind the self-funding limit. You cannot accept loans from family members or from any corporate accounts that you have access to. The loan must come from a bank or other recognized lending institution in Ontario and must be directed into the campaign account. Any interest that the campaign pays on loans is considered to be a campaign expense. Next slide, please. So Section 88.19 of the Municipal Elections Act outlines what constitutes an expense, and some examples of expenses are the replacement value of goods retained by the person, individual, corporation, or trade union from any previous election in the municipality and used in the current election, the value of contributions of goods or services, audit and accounting fees, interest on loans as identified under Section 88.17 of the Municipal Elections Act, the cost of holding fundraising functions, the cost of holding parties and making other expressions of appreciation after the close of voting. For a candidate, expenses relating to a recount or proceeding under Section 83, expenses related to a compliance audit, expenses that are incurred by a candidate with a disability or registered third-party advertiser who is an individual with a disability, are directly related to the disability and would not have been incurred but for the election to which the expenses relate. The cost of election campaign advertisements within the meaning of Section 88.3 of the Municipal Elections Act, or third-party advertisements as the case may be. So for greater certainty, the cost of holding fundraising functions does not include costs related to events or activities that are organized for such purposes as promoting public awareness of a candidate and at which the soliciting of contributions happens to be incidental, or promotional materials in which the soliciting of contributions is also incidental. Next slide, please. So candidates and third-party advertisers should familiarize themselves with the campaign expense provisions and know what constitutes an expense under the spending limits. This can be found in the Candidate's Guide, which there is a link at if you don't have it already, there's a link at the end of the slide deck. Campaign expenses are costs that are incurred by the candidate or a person under the candidate's direction, such as a campaign manager, along with a third-party advertiser in their campaign. The nomination fee that you pay at nomination is a personal expense and not a campaign expense. Therefore, it should not be recorded in your financial statement. Goods and services donated to the campaign are also expenses and must be reported. A receipt must be provided for the market value of that cost. Only nominated persons and/or third-party advertisers can incur expenses during their campaign period, or persons acting under their direction during those periods. All expenses must be paid directly from your campaign bank account, and a receipt must be retained that shows what the expense was for. So if you are using a credit card to pay for purchases, You should make sure to keep clear records showing that the expense on the credit card was reimbursed directly from the campaign account. All expenses must be reported in the relevant financial disclosure form to be filed with the clerk by the candidate or the third-party advertiser. With respect to campaign inventory, if you ran in the last election and want to use leftover goods, such as signs or office supplies, you have to determine the current market value for those goods and record them as an expense in the current campaign. Also, if you end up with leftover inventory at the end of this campaign, it becomes your personal property. But if you want to store them to use in another election, any costs associated for storage of those items are not considered campaign expenses. Next slide, please. So spending limits are outlined in Regulation 101-97. The head of council spending limit is $7,500 plus 85 cents per elector. All other offices are $5,000 plus 85 cents per elector. The spending limit after voting day for parties, expressions of appreciation, gifts, etc., is 10% of the general spending limit. The clerk's calculation for the spending limit is final. Next slide, please. So the clerk will provide two calculations of a candidate spending limit. The clerk will provide a preliminary estimate at the time of nomination for a candidate or registered third-party advertiser. The clerk's calculation of the spending limit is based on the number of electors on the voters list as it existed on September 20th, 2022. The final spending limit is based on the voters list as it exists on September 20th, 2026, and will be provided to candidates and third-party advertisers on or before September 30th, 2026. Whichever number of those two is higher is the spending limit, and the clerk's calculation is final. Candidates will be required to inform their contributors of the contribution limits, for example, how much a contributor can contribute to individual candidates' campaign, which was, I mentioned previously, the $1,200, and the aggregate limit on contributions to any one council or local board election, which is the $5,000. If a third-party advertiser has registered in more than one municipality, each registration is a separate campaign with its own spending limits. The campaign finance rules are generally the same for third-party advertisers as they are for candidates. For example, they are subject to similar contribution limits and have calculated spending limits. This includes financial filing requirements, requests for extensions, and records. Third-party advertisers are also required to ensure contributions and expenses are tracked and accounted for. There's proper record retention, proper direction is provided to those incurring expenses or accepting contributions on their behalf, and that spending limits are adhered to. Next slide, please. So most expenses are subject to the spending limit. Those listed in this slide are not. Expenses related to fundraising functions are exempt from the campaign spending limit, but in order to qualify as a fundraising function, an event must have the raising of money as its primary purpose. Campaign events at which, as I mentioned before, incidental fundraising takes place do not qualify as fundraising functions. For example, a brochure promoting awareness of a candidate that contains contact information to make campaign contributions, this does not qualify as a fundraising function. Next slide, please. So for third-party advertisers, there are also two spending limits, the general spending limit and then the separate limit for expenses related to parties and expressions of appreciation after the close of voting. Ontario Regulation 101-97 provides the formula for calculating third-party spending limits. That is $5,000 plus 5 cents per elector to a maximum of $25,000. The formula used is based also, as similar to the candidates, is based on the number of electors entitled to vote in an election in the municipality. Also the Municipal Elections Act also provides that the spending limit for parties and other expressions of appreciation after voting day be set at 10% of the general spending limit. This is consistent with what I mentioned earlier for the candidates. Next slide, please. So campaign financial rules can be found in the sections noted on this slide from the Municipal Elections Act. This and the next several slides will walk you through the campaign finance rules. As a candidate or third-party advertiser, it is important that you be fully aware of the responsibilities regarding election spending and accepting campaign contributions. You are recommended to familiarize yourself with the sections of the Municipal Elections Act that are noted on this slide, as well as the financial statements that you are required to file. This will help guide you in organizing your records and how they have to be reported at the end of your campaign. You are required under the Municipal Elections Act to keep accurate records and open a campaign bank account if you are spending any money or accepting any contributions. Just a note, as mentioned, I probably mentioned this a few times, a bank account is not required if a candidate or third-party advertiser does not receive nor spend any money. Next slide, please. So candidates and third-party advertisers are required to keep complete and accurate financial statements during the course of their campaigns. All contributions and expenses are to be accounted for and disclosed by the candidate on their relevant prescribed financial form. All candidates and third-party advertisers are required to keep all campaign financial records until after the council in the 2030 election has been sworn in and takes office. So these rules apply whether you are elected or not. The clerk must also keep all campaign finance records until after the 2030 council has also been sworn in. Next slide, please. So some recommendations that we have is store receipts in a secure place as they are valuable documents. Receipts must be signed by the candidate or his or her designate. It is good practice to have a receipt that is multi-part form, one for the contributor and one or more for your records. Receipts should be numbered in order. Open a bank account which provides monthly statements and canceled checks. Produce duplicate deposit slips. I know this is going back if you happen to have a bank book. I got asked this question, so not now, a lot of it's electronic, but in the event you have a bank book, get deposit slips that are duplicate slips for each deposit, listing the names of the contributors and the amounts received from each. Ensure a very good record is kept of all contributions, as sometimes a contributor makes numerous contributions and may exceed the $100 limit, where they will need to be identified within the financial statement. So there is a separate section on Form 4, the financial statement, that requires all contributors that contribute over $100 be listed separately with their address. So it is recommended that candidates make contributors aware that any contributions that exceed $100 will be identified within Form 4 and their address, and this information will be made public. Maintain a petty cash fund, if you need this, to handle minor expenses and obtain invoices to support all payments from the fund. At any time, the cash on hand plus the total amount of invoices should equal the original amount of the petty cash fund. The fund can be replenished periodically by a check withdrawn from the campaign account in an amount equal to the total amount of the invoices. So candidates and third-party advertisers may find it useful to look over Form 4, which is the financial statement for candidates, and Form 8, the financial statement for third-party advertisers, at the beginning of the campaign to give you an idea of what information will be needed to report at the end of the campaign. Candidates and third-party advertisers are required to maintain certain campaign records, for example, copies of advertisements for public inspection for a period of 4 years. This is outlined in Section 88.3 of the Municipal Elections Act. Next slide, please. So it is recommended that candidates also contact their municipality to ask about bylaws that relate to signs and campaigning. So candidates and third-party advertisers cannot cause an election campaign advertisement to appear unless they provide the following information to the broadcaster or publisher in writing. So the name of the candidate or registered third-party advertiser, the name, business address, and telephone number of the individual who is dealing with the broadcaster or publisher under the direction of the candidate or registered third-party advertiser. And the third-party advertiser must also include the name of the municipality where the third-party advertiser is registered. No broadcaster or publisher shall cause a campaign or third-party advertisement to appear unless the candidate has provided them with this information. The period for third-party advertisements, as shown on the slide, is a period when the rules for third-party advertisers applies. In 2026, this is from May 1st until the close of voting on voting day at 8 p.m. on October 26th. Just to note that an election sign advertisement purchased by or under the direction of a candidate shall identify the candidate's name. Next slide, please. The broadcaster or publisher of a third-party or candidate advertisement shall maintain records containing the following information for a period of 4 years after the date the advertisement appears and shall permit the public to inspect the records during normal business hours. So they must have the name of the candidate or registered third-party advertiser, the name, business address, and telephone number of the individual who deals with the broadcaster or publisher under the direction of the candidate or registered third-party advertiser, a copy of the advertisement or the means of reproducing it, and a statement of the charge that was made for its appearance. Next slide, please. So Section 88.25 of the Municipal Election Act states all candidates are required to file Form 4 with the clerk regardless of how much or how little they spent or fundraise. I know I say this a few times, but it's quite important. The deadline to file your financial statement is Tuesday, March 30th, 2027, before 2 p.m. If you feel that you cannot meet that deadline, you must apply to the courts for an extension prior to the March 30th deadline. If you filed a nomination form, again, you must file a Form 4. This form is required, again, even if you withdrew your nomination or you were acclaimed. If you registered as a third-party advertiser, again, you must complete Form 8. A candidate may resubmit a financial statement may resubmit a financial statement to correct an error up until the filing deadline. The clerk is required to make public a report of which candidates filed financial statements and which did not. Next slide, please. So candidates can also file their financial documents at any time after voting day to the end of the campaign period of December 31st, 2026, despite the March 30th, 2027 deadline. Filing of the financial statement ends the campaign period. This will make it easier for acclamations and campaigns where little or no expense was incurred. Third-party advertisers also can close their campaign and file their financial statements after early withdrawal or at any time after voting day up until December 31st, 2026. Keeping in mind the final deadline is March 30th, 2027. Clerks will be required to report whether candidates have met their financial filing obligations and publish this report on the municipal website or in another electronic form. This needs to be completed by April 30th in the case of a regular election. The clerk must also, as soon as possible after April 30th, 2027, make a list of all registered third-party advertisers and indicate whether each of them have filed the required financial statement and auditor's report. Clerks can determine the conditions for the electronic filing of financial statements if applicable. Next slide, please. So the appointment of an auditor by the candidate is mandatory if expenses or contributions exceed $10,000. Auditors must be licensed under the Public Accounting Act 2004. One of the recommendations that we have is that if you feel that you are going to meet the $10,000 threshold where you would be required to obtain an auditor, we recommend you go out early, seek an auditor early, because last previous election, some people struggled with trying to find an auditor. Note that financial statements are public documents. Next slide, please. So the nomination fee is only refundable if the financial statement is filed on time. A candidate or third-party advertiser who misses the filing deadline may file within the 30-day grace period, provided a $500 late filing fee is paid to the municipality. This 30-day grace period would end on April 29th, 2027. This is 30 days from the financial statement due date, which is March 30th, 2027. A candidate who chooses to file within the 30-day grace period will be subject to both the $500 late filing fee as well as the loss of their nomination refund. However, if the candidate is approved for an extension by the court, the candidate would then get back their nomination fee. A candidate or third-party advertiser may resubmit a financial statement to correct an error up until the filing deadline. Next slide, please. When filing the financial statement, a candidate or third-party advertiser with a campaign surplus must pay the entire amount to the clerk. Prior to paying over any surplus funds to the clerk, a candidate or third-party advertiser is entitled to a refund of any contributions they or their spouse, if an individual, made to the campaign, but they cannot refund anyone else's. So for example, if a candidate has $1,000 left over and they made a contribution themselves of $500, you would then repay yourself back the $500 and the remaining $500 would then be paid to the municipality. The clerk is required to place surplus monies in trust for use by the candidate if they need it for a compliance audit. The clerk is also required to place surplus monies in trusts for use by the third-party advertiser if they also need it for a compliance audit. If neither the candidate nor third-party advertiser requires the funds for these purposes, it becomes the property of the municipality or school board. Next slide, please. So in this section, I'm just going to cover compliance and enforcement. Every municipality must establish a compliance audit committee. Members of a compliance audit committee cannot be members of the council or school board, an employee, a candidate in the election, or a registered third-party advertiser. The clerk reviews contributions and prepares a report for consideration by the compliance audit committee if a contributor appears to have exceeded any of the contribution limits. So this process is related to reviewing contributions as reported on the financial statements and is not connected to the actual compliance audit process. If it is apparent to the clerk that a contributor has exceeded one or more of the contribution limits, the clerk would report this to the committee, which would meet to determine whether to proceed with legal action. The legislation does not specify what details are to be provided by the clerk in their report to the committee. Electors entitled to vote in an election may apply for a compliance audit even if the candidate has not filed a financial statement. The application must be in writing, and it sets out the electors' reasons for why they believe the Municipal Elections Act has been contravened. The application must be submitted to the clerk or the secretary of the school board within 90 days of the filing deadline. The Compliance Audit Committee will consider the application and decide whether to retain an auditor to undertake a compliance audit of the candidate's financial statements. A person who does not want to or who is not able to apply for a compliance audit may decide to commence legal action on their own. A prosecution related to the 2026 election must be commenced on or before November 15th, 2030. Next slide, please. So if a committee grants an application that has been submitted, it will appoint an auditor to conduct a compliance audit of the candidate's campaign finances. The auditor is entitled to have access to all of the financial records related to the campaign, which is why it's very, very important to keep good records. The auditor will produce a report, which the candidate is entitled to also receive. The Compliance Audit Committee will meet to consider the auditor's report. If the report concludes that there is an apparent contravention of the Municipal Elections Act, the committee will decide whether to commence legal action. The Compliance Audit Committee does not have any authority to set penalties. Only the court can decide if you have contravened the act, and if so, which penalties should apply. Next slide, please. So this slide that kind of lays out the automatic penalties. There are 3 contraventions of the Municipal Elections Act where penalties apply automatically. If you fail to file a financial statement by the end of the 30-day grace period, or fail to apply to the court before March 30th, 2027 for an extension by the filing deadline, if your financial statement shows that you have exceeded your spending limit, or if you fail to turn over your surplus to the clerk when you file your financial statement. So the penalty for this is that you forfeit your office if you won the election, and you become ineligible to run or be appointed to fill a vacancy until after the 2030 election. Next slide, please. If you are convicted of an offense, you may be subject to the following penalties: a fine of up to $25,000, ineligibility to vote or run in the next general election, up to 6 months in prison, forfeiture of your elected office if the judge finds that you committed the offense knowingly. So I previously indicated that if you were convicted of exceeding the spending limit, you automatically lose your seat. So in addition, you may also be fined the amount of which you exceeded the limit. Next slide. So this slide, I'm going to go over the voters list and proxy voting. So Elections Ontario is a non-partisan office of the Legislative Assembly of Ontario, responsible for administering provincial elections, led by the Chief Electoral Officer. Elections Ontario is governed by the Elections Act and the Election Finances Act. Elections Ontario does not administer local elections, but they do have a role to play in providing up-to-date voters list information to local partners. Since January 1st, 2024, the Chief Electoral Officer, Elections Ontario, has taken over the responsibility of preparing voters lists from MPAC and will manage a permanent register of electors for both provincial and municipal elections. The voters list for each municipal election will be prepared using data from the Permanent Register of Electors maintained by Elections Ontario. Elections Ontario works with local partners to provide them with the most up-to-date voters list to support their elections. Voters across the province can update their information in the register for local and provincial elections by visiting registertovoteon.ca. Voters there can confirm or add their information to the register. Next slide, please. Okay, so the voters list becomes a public document on September 1st, 2026. As a candidate, you can request that the municipal clerk provide you with a copy with the part of the voters list that relates to the office that you are running for. This request must be made in writing. In order to receive the voters list from the municipal clerk, you must give the clerk a written acknowledgement of the following information: that you will only use the list for electoral purposes and not for commercial purposes. You are bound by the restrictions set out in the Municipal Elections Act relating to the handling of the voters list, and you will only share the list with others, such as campaign workers, after obtaining a similar written acknowledgement from them. Next slide, please. So you are the candidate is the only person who may share the voters list. If the candidate has given someone a copy, they are not allowed to share it further. As a candidate, you must keep track of who you have shared the voters list with. If you give someone a physical copy of the list, they must return that copy to you. If you shared an electronic copy, you must destroy the copy and provide you with a written acknowledgement that the copy has been destroyed. You cannot keep copies of the voters list after your campaign is ended. So on or before the day your campaign ends, you must destroy the copy of the voters list that you received from the clerk, have any printed copies that you shared with other people returned to you, and destroy them. Ensure you have received written acknowledgements from anyone who received an electronic copy of the list that the electronic copy has been destroyed. Next slide, please. So before you share the voters list with someone as a candidate, you must obtain a written acknowledgement from that person. That written acknowledgement must confirm, it's very similar to what you provide to the clerk, but it must confirm that they will only use the list for electoral purposes and not for commercial purposes. They will not share or give copies of the list to anyone else. If they receive a physical copy of the list, they will return that copy to you. And if they received an electronic copy of the list, they will destroy the copy and give you a written confirmation that the electronic copy has been destroyed. The written acknowledgement should set out the dates by which people must return physical copies to you, or give you written confirmation that the electronic copies have been destroyed. You must keep the records of these written acknowledgements that you have received until November 15th, 2030, when the next council or school board takes office. You must also keep any written confirmations that electronic copies of the list have also been destroyed. Next slide, please. So I'm just going to cover voting proxy. There are a number of reasons why someone would appoint someone else to vote on their behalf, including absence from the area or possible illness. Section 44 of the Municipal Elections Act covers the issuance of proxy forms. No appointments for proxies are made until all nominations are closed. The clerk may designate a place and time for presentation of proxy voting applications and appointment forms for clerk certification. Assignment of proxy vote is the responsibility of an eligible voter to appoint an identified eligible voter. The eligible proxy may exercise only one proxy vote unless the proxy is acting on behalf of a spouse, sibling, parent, child, grandparent, or grandchild. And this is laid out in section 44, subsection 2 and subsection 3 of the Municipal Elections Act. Proxy forms must be filled out completely before being signed and have original signatures. Just to note that to appoint a voting proxy, you must fill out 2 copies of the appointment for voting proxy forms, and both copies must have original signatures. So please check with your municipal clerk if proxy voting is available, as municipalities that use alternative voting methods may not permit proxy voting. So now I'll just cover, I'm almost done, we're getting very close to wrapping up, and scrutineers, recounts, and then key dates and some resources. Next, yeah. So only a candidate may appoint a scrutineer to represent him or her during the voting and the counting of votes, including during a recount. Third-party advertisers cannot appoint scrutineers. In the traditional election where voting takes place at a poll, the deputy returning officer is in charge of the activity in the voting place, and the deputy returning officer may ask the scrutineer to leave if the scrutineer is not compliant with legislation. Candidates and scrutineers should respect the deputy returning officer must ensure fairness, access, privacy, and security of the vote, and absolutely no campaigning within the voting place. So this means scrutineers cannot enter the voting place wearing a pin or shirt with any reference to candidates. A useful tip that we provide is check with the clerk to see if a list of scrutineers' rights is being provided to each election staff at the poll. If so, potentially you could use that list or prepare your own and hand out to each of the scrutineers a list of their rights, which are spelled out in section 47, subsection 5 of the Municipal Elections Act. Just to note, there are no age restrictions for scrutineers. Next slide, please. So a recount is automatic if the vote is tied. Councils have the option of establishing policies prior to the election that also may allow for an automatic recount. Council still retains the option to pass a resolution for a recount within 30 days after the clerk has declared the results of the election. An eligible elector can apply to the courts for a recount within 30 days of the clerk's declaration of the results as well. Next slide, please. Okay, so here we just have listed some key dates. Just to note, voting day is Monday, October 26, 2026, between 10 a.m. and 8 p.m. Unless there potentially are reduced hours that are set by the clerk for retirement homes and certain institutions. The campaign period, the time when a candidate can accept contributions and incur election expenses, runs from the date the nomination has been submitted up until December 31st, 2026. The campaign period, the time for third-party advertisers to incur expenses, begins on the date their registration is certified until December 31st, 2026. The deadline for filing of the campaign financial statements in the clerk's office is Tuesday, March 30th, 2027, no later than 2 p.m. All candidates and third-party advertisers must file the statement regardless of how much they spent or received in contributions. Next slide, please. So here's a list of resources that are available to you in order to prepare yourself for your campaign. You'll want to be very familiar with the Municipal Elections Act, the Municipal Act, and the Municipal Conflict of Interest Act. Also, there are links here to the Candidates Guide, Third-Party Advertisers Guide, and the Voters Guide. I believe that everyone will be posting this on their website, so the links will be available. And we strongly recommend you read the Candidates Guide. It's very, very helpful. And then the next slide is this. So the slide after this is my contact information and Davin's. So we will take some questions, whatever questions you have now, but if in the future, if you have any other questions, you're welcome to reach out to us as well. And that's all we got.
Thank you very much. If anybody would like to ask any questions of our representatives from the ministry, please come up to our podium here and just press the button and when it turns green. And just a reminder, this is being live streamed, so your comments are live streamed on our YouTube channel and they will be on video on there.
Oh, okay, it has to be green, okay. Ooh. I have 5 questions, actually, some for clarification. One was campaign contributions under $25 did not require a receipt, yet a $25 ticket did require a receipt, if I read that right.
Okay, so all contributions have to have a receipt, every single contribution. Regardless of how much it is. If it's the only thing, if it's 25 or under, you can accept cash. If it's over 25, it has to be money order, check.
No, but also under $25, you can accept cash, but it still needs a receipt.
Yes, the only time you don't need a receipt is if it's a fundraising event and you do kind of like a pass the hat kind of thing. If it's under that amount, under 25 or under, then that's when you don't have to do a receipt. Otherwise, you have to. So I think they talked about, we had mentioned if you have a fundraising event and you're selling tickets, regardless of the amount, then you also have to have a receipt. It's just if you have like a pass the hat kind of thing at a fundraising event.
Okay, the next question is expenses that are not subject to general spending limits, including fundraisers and events. Like, I need some clarification
Yeah.
on that. Like,
So it kind of mentions that there's lots of good information in the candidate's guide about fundraising events because they are a bit complicated. There's a separate section in the financial statement that covers the fundraising event. So sometimes if you read that section, but some of it will qualify as an income instead of a contribution. So just review that section and that will lay it out. But if you once you look it over and if you have questions, please reach out to me and I'll help you.
Okay, and just on the same thing, like, we have some venues where it's quite customary that they will provide the venue, provided they get the bar. They do it for charity events, they do it for everything. So I'm assuming for a campaign, then it would be the same thing.
Right, because you're not accepting a contribution from them or any kind
No.
of discount. It's just that's what they charge. So
Yeah, but there wouldn't necessarily have to be a charge for the venue.
right, if
that's
there's
what
not
they
if
did.
it's normally not a charge, then that would
Okay. This one is a question that's come up. It's use of municipal resources.
Right.
So I've personally been a counselor for 11 years.
Okay.
For 11 years, I constantly communicate events to our residents, whether they're on town property or otherwise. So my understanding is that we continued to do the job as we always did the job. An example would be this morning there was a flag raising. It was at Town Hall. Now, normally I would take photographs of that and I would communicate to our residents, not in any kind of campaign, no campaign sign or anything else, just saying as, hey, we attended a flag raising today and here's what it was about. I just want some clarification. And my understanding is that's a counselor just continuing to do their regular job as a counselor.
So the Municipal Elections Act doesn't, so they leave that up to the municipality to pass a bylaw to address municipal resources. So you'd have to talk to your clerk.
Okay. So there's some gray area there, is what we're saying.
We don't address that, we leave it up to the clerk.
Yeah, okay. Okay, just clarification, you indicated like often, with Vistaprint and different things, we're using a charge card. It could be a personal charge card, obviously, to pay a bill. We just then have to properly record how that's been reimbursed out of our campaign bank account.
Right, so like a credit card you're talking about?
Sorry?
A credit card? Is that?
Yes.
Yeah, so you can use a credit card, you just have to keep very clear records, so that in the event of a compliance audit, that you can prove that you paid the expense directly from your campaign account and that the amount was for your campaign.
Okay. My last question, it indicated that accounting and audit fees were not included as campaign expenses.
So it's not included in your spending limit part, right? So you have the spending limits.
Oh, okay, but it's still a campaign expense and it can still, you can still.
There's a separate section, yes.
And they can still be then covered by donations,
Contributions, yeah.
yeah, okay.
Yes, everything has to be covered by contributions, yeah.
Okay, perfect, thank you.
You're welcome.
I just have a question around, great presentation, by the way, thank you for
thank
that. Just a question around the $25 pass the hat kind of no receipt thing versus the $100 where it has to be like assigned to a name. So are you suggesting that someone who donates under $100 can be an anonymous donor?
No. So when I talked about the $100, so if one candidate contributes over $100, if a contributor contributes over $100, there's a separate part in the financial statement where you have to record their name and address. So the rest of it, if it's under, so you may accept, so it's nothing to do with the pass the hat because that's anonymous. But any other contributions, whether it's they do four contributions of $25, however it is, if they reach over $100, there's a separate section where you have to list their name and address.
So how do you record a donation that's under $100? That wasn't the pass the hat.
So you don't have to list their name, but you have to keep receipts. So if you're in the event of a compliance audit, it's just a different area that you record that contribution. Yeah, so I think, I don't have it in front of me, but yeah, if you look at it and if you have any questions, reach out. But yeah, it's just that they all have to be recorded, but then there's another section that gives more detail for over $100.
Got it. Okay, thanks.
You're welcome.
Hey guys, how are you?
Good.
Nicole, are you able to touch on Joe's question there about the flag raising ceremony this morning?
Yeah, Carly and I just flagged that we're going to provide a response in writing, so everybody has it tomorrow. Yeah.
Thank you.
Yeah.
Sorry, I'm still unclear, Richard's question. So you're saying a receipt under $25 needs a receipt, but no name and address?
Okay, so you need to record it on the receipt, right? So you need to have the name and address on your receipt, but you just don't have to record the name and address on the financial statement. That's the public document.
Oh, I see,
right?
okay.
Yeah.
So on your
So
ledger.
everything on a receipt, so in the event of compliance audit, you have to prove that all your contributions were eligible contributors. So you do have to have addresses and with that.
Anybody else want to come up to the podium? All right. Oh, there we go.
Sorry, just thought of one. If a candidate is acclaimed and they were running with others as sort of a group, would they still be able to include signs or advertisements with them after the closing filing date?
As long as it's their campaign, so if they want to keep campaigning, I mean, there's nothing in the Municipal Elections Act that prevents them from campaigning.
Okay, great, thanks.
You're welcome.
Anybody else? Well, I want to thank everyone for coming tonight, especially our representatives from the ministry and the town of Collingwood and the town of Wasaga Beach. Please enjoy any of the refreshments outside, and I don't know if they will still be behind for maybe a couple minutes if there's some more one-on-one conversations, and then clerk's departments will be here too if you have any direct questions for us. Sorry, Sarah, go ahead.
Sorry, I do have a quick question. If you could raise your hands for the municipality that you're here interested in. So those that are here, part of Wasaga Beach, if you could raise your hand. Ooh, great contingency, wonderful. Those from Clearview? Great, and anybody from Collingwood? Yes. All right, interesting, I just wanted to check that out.
There's prizes, there's refreshments in there. Thank you very much, everybody.